So thank you everyone for your patience with lunch and the photography. The weather just really cleared up, so it was just an opportunity we couldn't pass up. I wanted to briefly introduce our next moderator. Is a man in many respects need no introduction. Bill Slate, who is also one of the conference sponsors in his professional and his personal capacity. He's the head of the American Arbitration Association and was keenly involved in the development of the International Center for the Settlement. I'm going to mix it up. So you do it.
Center for Dispute.
ICDR, and there's plenty of little jump flash drives that you can collect in the front. He's been on the hot seat about arbitration. He's been creating alternative dispute resolution for quite a long time, and he is going to grace us with his presence as a moderator and be fabulously on time, as well as synthesizing those blog comments.
Thank you very much indeed, Susan, and may I join the legion of others who have sincerely expressed their high regard and appreciation to Susan and to Anna, to Huntad, and to WNL for this wonderful, wonderful program. Well, here we are, and as you will know from the program, this panel before you presently will be exploring existing strategies. I think the operative word for us is existing strategies and innovations for preventing and managing investment treaty disputes efficiently. And you have a panel of speakers here which is deeply experienced and valuably varied, shall I say, in their perspectives. And I would refer you to the superb compilation of speakers' biographies in your program, materials for information on their many and glorious achievements. But for now, I will identify them for you by name and working title only, and begin by introducing to my far right Meg Kinnear, who is the Secretary General of ICSID. To her immediate left is Aguie Lendor, who is the Manager of Trade and Investment Policies at the Center of Export and Investment of the Dominican Republic. With us virtually, on screen, is Michael McIlwrath, who's Senior Counsel at General Electric, Infrastructure, Oil and Gas. Regrettably, Paul Paredes from Peru is not able to be with us today, but at a key moment, happily, Anna will have a word to say about Peruvian law. To my immediate left is Andrea Schneider, who's a professor of law at Marquette University School of Law, and to her left, our esteemed commentator, Josh Kallmer, who's Deputy Assistant U.S. Trade Representative for Investment at the Office of U.S. Trade Representation. We will, of course, welcome your questions and comments a little differently for this panel. First, at the conclusion of each speaker's presentation, I will select one question from among you to prime the pump, if you will, for the more fulsome Q&A which will occur later. And that will take place during the coda, the final movement of the session. So let us begin in earnest with observations from Meg Kinnear on, among other topics, the conciliation mechanism at ICSID. Meg?
Well, thank you. I also would like to say I'm very grateful to be here and have this opportunity, because there is a lot to be learned, and I'm here or because I have a lot to learn today as opposed to having a lot to learn. My thoughts today are based both on my experience recently at ICSID, as well as the institutional experience of ICSID, but also on the observations that I formed as a government counsel doing investors' trade and participating in bid negotiations. And when I originally pinned these thoughts, I actually thought I had some interesting and unique insights. As I heard people talk this morning, I started scratching them off. And what I can tell you is I'm now congratulating myself on really having my finger on the pulse of what everybody is thinking, because I have a few unique thoughts left. So I will certainly be brief if nothing else. I'd like to start with 2 points that relate to the prevention aspect of all of this. And first of all is the whole question of treaty design. To my mind, treaty design is absolutely critical, and in particular, not only what is included in the bid, but what is not included in the bid. And once we design your treaty, and probably the same could be said for contract design, equally important is having a way to let those who are charged with compliance know what you did undertake on behalf of the state or on behalf of the party that you represent. In the bid context, this is especially so with respect to both national and subnational levels of government, and there really needs to be a mechanism to consciously factor in bid obligations into policy development. And so, for example, some states have set up various mechanisms. For example, before a new law is passed, that one of the areas where legal advice will be given is this consistent with our investment or trade obligations? And if it's not, can we get where we want to go from a policy perspective while still respecting our investment treaty obligations? Having that kind of advisory function at an early stage, I think, is key to prevention in this whole area. Second is the whole question of an early and well-reasoned evaluation. And the cooling off period or consultations in the bid, I think, are one opportunity that probably are not as well used for evaluation and settlement purposes as they might be. And I think that's probably because of the very real situation you find yourself in particular if you are the state. You really don't have a lot of time to be getting ready for what is the next step in the whole issue, which is a possibly long and detailed arbitration. But it may well be an opportunity missed. So having that early evaluation is very, very important. And then not just the early evaluation, but being able to go back to it at various stages as you learn more about FAST or have a better handle on your potential liability is also quite key. And I know that there has at times been experiments or efforts to even have parallel teams, a settlement team and a litigation team. And one of the drawbacks to that, of course, is it's quite intensive in terms of resource intensive and also creates just one more thing to coordinate. But it can be very useful to have one team or even one or two people whose whole function is to say, knowing what we know as we go through this process, are we now at a stage where we'd like to think about options other than continuing on the whole arbitration issue. In terms of ICSID's experience, it clearly has been that many cases are apt for early resolution. You've heard some of the statistics this morning. Professor Reisman told us about 34% of all ICSID cases are discontinued before a final award is rendered. And we believe that a great many of these are cases where parties have reached some kind of a settlement or a mediated resolution, and that's the cause of the discontinuance. Add on to that a further 10% of the awards that are rendered which memorialize a settlement agreement between the parties. And we suspect that a great many of these are reached in a very informal way, probably in a fairly traditional solicitor-to-solicitor settlement negotiation kind of situation. But if you add those numbers, the 34 and 10%, you're getting approximately 44% of the cases not going to a final adjudicated result on either the merits or jurisdiction. So it does raise the intriguing question for that additional or for the leftover 56%. To what extent can we use alternate tools to resolve an even greater number of cases? And to what extent are those the cases that are on an arbitration track for better or worse? And as a result, maybe your focus is best to simply have the most time and cost-effective arbitration and to go forward. And that's probably the million-dollar question for everybody in this room today. ICSID, as you know, has had some experience with conciliation. The ICSID convention was accompanied by a formal conciliation mechanism, and that was also brought along in the additional facility. And while it was certainly very innovative, I would say, for 1966, when you think that really what we've learned in the whole ADR world is probably in the last 20 years, and that's when we've really had the bulk of experience. It unfortunately has not proved to be a mechanism that parties have used often. The scorecard is that there have been 6 conciliation cases in ICSID's history. Compare that to roughly 310 arbitration cases to date. So that's about 2%. An even perhaps more disappointing statistic is that of those 6, 1 resulted in a conciliation committee reporting an agreement. 2 settled before the conciliation committee was actually struck. And the remaining 3 resulted in reports from a conciliation committee reporting a failure to resolve the dispute. And I know two main factors that we point to. First of all, the rules require written consent of both parties, and that is often absent. So right there, that prevents you from going down that route. Secondly, and probably the biggest obstacle, is that these conciliation rules are relatively formal, relatively structured. Each step has a particular time frame, a structured procedure for appointing the conciliation commission. So it is not the kind of nimble or flexible tool that you probably would want if you were going to go into an alternate form of dispute resolution. But at the very least, what I think you can take from that is that there is now, and always has been at least, a commitment at ICSID to offer a facility not just for arbitration of disputes, but also for non-arbitral dispute settlement. And the real question is, how do we do this effectively? I don't know the answer. That's why I'm here today, obviously. But looking ahead, ICSID is very much interested in being part of this discussion. At various times, ICSID has thought whether it could usefully offer some kind of a mediation mechanism, and that's been considered both in terms of ICSID alone or other parts of the bank, for example, MEGA or other parts of the bank that might also have an ability to use and to contribute to a mediation mechanism. We have also very recently been speaking with Anna about whether there would be some benefit out of having some kind of a pilot project on the side, obviously consensually among the parties, but to at least get more statistics or more practical on-the-ground information about how we might sculpt some of these alternate mechanisms and what's most useful to the parties. Thinking through what I've heard today, it seems to me that maybe even one step back, as Mark said, might be very useful, which is at least getting more on-the-ground information about when parties do settle or do discontinue. Why is it? What was their experience? What might have been a helpful tool? It may be that might be even more useful information that we find a way to try and get. But all through this, there are certainly a lot of open questions, and I think among the toughest are who are, for want of a better term, the mediators, the people who will help whatever process you have, help that process go through. I think that's a very difficult question. Another very difficult one is what is the relationship between the alternate resolution and the arbitral process? Are these things that you do in parallel? Is one mandatory? And how do you keep the cost down? That is a huge, huge question, I think, because for everyone that settles, if you spend a lot of time and effort and not got to a result that the parties are happy with, you're then back to square one on the arbitration route. So getting our head around that has been very important, but also very difficult. At the end of the day, it seems that success can probably only happen if we realize, first of all, as a premise, that not every dispute can be alternately resolved, and that the definition of success will probably come from finding a way very quickly and very early to determine which are the ones that have the potential to settle, and which are the ones that really should just follow the arbitration mechanism. So I haven't given you a lot of solutions, but I have posed a lot of the questions, and I look forward to my co-panelists for their thoughts. Thank you.
Well, as I promised, I'm prepared to take one question, one-part question, not a two-part question. Does anybody have a question of Meg Kinnear that you'd like to ask now? You'll have another opportunity at the more fulsome Q&A period. Meg, someone did note on Facebook that your reference to 6 conciliation cases, yes, but the suggestion here was that nearly all of those are not investment treaty cases. Is that so? Is that good information?
Eloise knows that better than I. I'll defer to
They
her.
were all based on contracts.
All based on contract.
All based on
Except one.
One was.
Okay. All right. An interesting clarification. I think we have one question. I'll consider this the one question. Please.
You had talked about making use of these processes on a consensual basis, and I'm wondering, do you think there would be any value in looking at the United States experience with the introduction of mandatory mediation, even if it's on a sunset basis, in order to force, essentially, the education of lawyers and parties, repeat player parties, regarding the use of this procedure?
I don't have a closed mind about this, but my gut reaction is no. In this universe, especially where more and more of our caseload is bilateral investment treaty, I think if you help you get that much farther ahead, or be the best use of the resources you have, frankly.
Well, thank you, and thank you again, Maggie. We will next hear from Aguie Lendor, who will contemplate, among other strategies, the prevention of disputes. Aggie.
Well, good afternoon. First, I want to thank Anna and Susan, especially, and also Celeste, because she has been a great help. And Susan has tremendous skills in organization. I'm very surprised. I am actually challenged because the very few points I had, Meg already has spoken about them. So I think I will focus a lot on the practical area and what we're doing in the Dominican Republic in prevention. Because as we heard this morning, Professor Michael Reisman, he says that we have a number of multinational investing, and he gave us huge numbers, and he said that only very few cases of those are going to arbitration. That may be true, and I fully agree with him, but for developing countries, this very small amount of cases that are awarded are huge for our economies, and we really have to think of prevention as an important way, not an alternative way, but the way to go. The first thing I believe we should be doing in our countries is slowing down the signing of bids. We need to, I believe this should be left for when governments are truly ready and for when we definitely attract foreign direct investment. And I think Meg spoke a little bit about that. Ecuador is actually working on this, and it's very interesting what they're doing and revising and recalling some of their bids. That's an interesting approach. I do think that this money and energy should go to reinforce and work within our governments to make sure that our laws and policies are properly applied and our institutions get a lot stronger. In this sense, what we're thinking and doing at the Center of Export Investment is, and this may be the practical answer to your blogs and to your reports, is that first we have created the institution that you mentioned in the reports to attract further investment and to deal with everything they need to. And we have created this department that is called Aftercare. And Aftercare should be having breakfast, lunch, dinner, going to the supermarket with investors. They should really know them inside out. They should talk to the CEOs. They should be talking to the managers, supervisors. So not only will they know when there is a problem, but they will be able to foresee when a problem may arise. And this is very important. We're kind of doing it with weekly visits already and doing a matrix where problems may be and giving it to my department, which is policy and investment, so we can actually go where policy has to be changed or maybe administrative measures can be taken. That should definitely help. And this also works for the private sector and for the public sector. In the private sector, we can work with our local companies and SMEs, creating the right linkages so we can, have a better use of our supply chain to these multinationals. This will improve our economies. We also will work with our other government institutions, because in doing so, these other institutions will actually understand where the problems are. You can have a better assessment for the training capabilities. You can train the employees they may have. So every money and every penny we get in our government can be better focused, because we know the exact needs, and we can know how to, the main goals is both to get less awards, but also to get a lot of more reinvestment in the economy. And this department, if our law allows us someday, should lead into having the investment ombudsman, and that's the figure. For these to work properly, they need to have a clear mandate. They need to have a clear mandate by law. They need empowerment, and they need budget. So these three things are extremely necessary for this idea to actually work in our country. But if after all these efforts, a notification is awarded, and so this notification arises or comes to the authorities, then we think we need to do the best use we have of conciliation and mediation and the mediation process. this is definitely important for us because we really have to have our main goal not to have any cases at exit. Not because they're not doing a great job, which I think they are, but because it's extremely costly for the government. I think exit is absolutely necessary if all these things do not work. So in this sense, we have read already here and heard of the many challenges this figure has, the mediation and the empowerment and all the obstacles. But we need to find a way to make it work. We need to use our great minds that are all here together and find a way to make it work because developing countries do need this figure to be reinforced. In this sense, we want to suggest, and that Meg has already done so a little bit, is that I believe that we need a strong partner for the mediation process, at least in countries like ours. And we think that UNCTAD, under the International Investment Agreement section, has a key role to play here, since it is a reliable institution that can serve as a great mediator among our countries and our investors. I think if this happens, it will create a huge impact on the way we see investment disputes mechanisms and resolutions today.
Well, Aguie, thank you very much for this very fresh and interesting perspective. We've heard a great deal already today, and I think most people in this room agree that a state, a governmental party in the mix changes the perceived dynamic of whether or not mediation is going to be successful. But now you, as a representative of the state, are making what appears to be a request, not a plea, to inculcate this more structurally into the process. So may I ask you this question? One tweet poses this question. There's much talk today regarding when and how to talk settlement and who should introduce the topic. Is there a stigma to settling?
I actually had that written down before, and I was saying that settling down is not sitting down.
Settling down is not sitting down.
Something that answers.
All right. So there is not. That's what we would say. Question? Yes, sir. Please. Would you identify yourself and pose your question?
My name is Richard Kallmer, and I work in the Office of the President in Rwanda. Now, from a government perspective, obviously, it will be difficult for each other government, like Rwanda, for example, that please do not sign VITs, because the move now in Rwanda is to sign as many VITs in every country as possible. So the idea is, for the VITs that are being signed, probably we should make provisions for preventing and managing disputes. Maybe, I don't know how that's possible, but maybe putting in the VITs a section saying before the dispute goes to X, they should first try local remedies, because the best way possible, for example, like Rwanda or for very many developing countries, first without capacity and second without the necessary institutions. Because some of the institutions in Rwanda, some of the institutions in the country, they're not yet that strong. They're not yet, so we need to think of ways in which we can A, strengthen the institutions within different governments, and B, give capacity to the local staff in these countries. I think this will help. This will help A, reducing disputes, and B, also will help in giving investors confidence. Otherwise, sometimes you find you go to a country, you're negotiating with people in different countries, but you don't understand even the basic provisions. So capacity building becomes important, but also strengthening the institutions becomes very vital. The second thing is, for countries that are interested in signing VIPs, I think we should encourage them to keep signing them, because if that's not to help them attract investors, then so be it. That's what I think would be one of the best solutions.
Thank you for that observation. Comment? Yes, sir.
When I said that we should slow down bits, I also said that there are two exceptions. One is when governments are ready, and second is when this country really need a bid to promote their direct investment. Some countries are not having any political issues, or their economies is going more or less okay, and the local laws already establish the same provisions that bids do. So in those senses, it may not make so much sense to be signing bids for those countries. There are others in Latin America also happens, but there are many countries that that actually get a lot of a great use of their base, and that it has a lot of advantages for that.
All right, well, thank you. I thank you very much again, Aggie. I think it's time now to hear from Michael McIlwrath, who is with us virtually here. And he will share his views from the point of view of a provider of technology and services that has traditionally not played in the area of investment disputes. One might ask why. Perhaps Michael will answer that, and what they may think is missing. Michael, can you hear us? Can we hear you?
I can hear you very well. Can you hear me?
We can indeed. Welcome.
I know that you can see me because while I'm honored to be here, a number of my friends who were there in the audience have pointed out that I was on camera earlier while I was finishing my dinner. And for the record, for those of you who think that, although it's evening here in Italy, that I'm having a very exotic and delicious Italian dinner, just for the record, it was the Philadelphia cream cheese and grits crackers. Or Benedict cheese. So I think that you probably, if you wanted to go to a conference and have a good meal, you're better off being with you all there today than here with me in Florence. Bill, thank you very much. In fact, one might ask, why am I here? Because I do not hold myself out as an investment dispute expert. GE does not typically play in this field. You said we consider ourselves to be a company that likes to grow with countries, that we want to be part of the infrastructure and environment that's destined to expand. And just to be, by way of an example, India in the past year became within GE the first country to become a division of the company. We actually have what we call an India P&L, India Profit and Loss Center, because we recognize that it's a country that's destined to grow, and our view is to grow with them over time. So in my brief pitch here, I'd like to talk a little bit about, let's say, investment disputes that were not, or investment disputes that we didn't have. The story of one international commercial arbitration with an emerging country that we had, and how it might have been handled differently. And I want to conclude very briefly with what investment mediation, if it existed in a more formal form, what it might look like, in our view, might be able to be something that would be working. Very, very quickly, let me tell you about a couple of investment disputes that were not, that never got off the ground. And they were both investment disputes, actually, that I pitched to the company that we should consider taking action under a bilateral investment treaty. The first one was not for a lot of money. It was, well, relatively speaking, as investment disputes go, it was for about $2 million in a case in a country, against a country in Asia, for a denial of justice claim. It was actually a case where we had an ICC arbitration award rendered in 1998 against a state-owned company, and after 10 years, we still were in the process of trying to get the International Arbitration Award recognized in the country. And we took a look at a potential investment claim for denial of justice. But when we raised it within the company, it was the same answer as in the next case I'll tell you about, which is that we have a lot of financial interest in that company, and $2 million didn't get us there in terms of a dispute being big enough for the company to go to litigation with the country. Second dispute that did not come into existence was larger. It's about it was about a $10 million claim. This one was in the Arab Gulf. Again, would have been a denial of justice claim. It would have been one where we had what we thought were contractual rights. But also, in this case, the company's view was that the financial interests in this particular country were like in the other case, one where you could add not just 1 zero, but maybe 2 zeros to our financial interest in the country on any particular year. So we did not pursue the option of putting, or what we thought would be putting our company on the line, our reputation on the line with the country. Although I'm sure that the company in some way factors in these results when we go to do contracts in these countries. The fact that, well, we do have rights to be paid, but we don't collect them. It does come into the risk assessment process that we Now I'd like to turn to, very quickly, talking about the cases that we did not have, about one that we did have. It wasn't an investment dispute, but rather was an international commercial arbitration that we had with an Eastern European country. The contract was one to rebuild aging transportation infrastructure in the country, and the contract was canceled after it got underway. It was a simple breach of contract, and we looked at running this either as a arbitration under the institution that was named in the contract, or possibly as an investment arbitration. We made the decision ultimately to go with the institution named in the contract and treat this as if it were any other contractual breach, mainly because there's a perception of speed and cost. We thought that we could get it over more quickly and cheaply. Took about 2 years, and we're actually in the process of enforcing it. We ultimately wound up with a $20 million arbitration award, covering also our lost profits. And you could say, oh, nice story. And in fact, it is a nice story for me, the lawyer. It's actually a bad story for the business. So I'd like to give you the other side of this story, that for the lawyer was a very nice outcome, but for our business interests was something that I would say was not an outcome that at the outset we really wished upon ourselves or our other contracting party. What we wanted in that case was a deal to have been honored. We would have been willing to reconfigure the contract. We would have been willing to find other ways of providing the same or similar services within that country so that something would actually have been built. The result that we got was, from a lawyer's point of view, the right outcome. We had a contract, there were expected profits. We are now in the process of collecting those profits for which we contracted. But our partner didn't get the infrastructure rebuilt, and that's where we really would have wanted to have been. But that opportunity has now come and gone. What was missing in the entire process, from our point of view, was a formal system for resolving the dispute. What we lacked was a formal mediation mechanism, a formal negotiation mechanism that would have allowed us to resolve the dispute with high-level buy-in from the other party. Now, we actually did have high-level involvement. Actually, I was personally involved in meetings with the Prime Minister. It was a very big dispute. There was a will to resolve disputes. But I think that Meg pointed out this in her presentation, that I think that there was a failure on the part of our other party, the country that was involved, to do a very good, early and well-reasoned evaluation of what the likely outcome was going to be. And I'm fairly confident that had there been mediation, had there been a formal mechanism for us to resolve this dispute, we probably could have found a way to work it out. But as many of my colleagues pointed out, because we have lots of people involved in trying to come up with a negotiated solution, it was often like trying to push a rope. I was listening to the stream earlier, and I heard, I believe it was Mark Claudfelt who made the point that mediation tends not to be adopted in many cases because the parties don't seem to want the option. What I'd say in our experience, it's usually not so much that the parties don't want the option, it's that one of them is very unfamiliar with that option, which leads to what they think is an outcome they don't want it. So if we were to take our own experiences, and I take this case in particular, and say if we were to have an investment mediation option, what might it look like, or what would it need to look like based on our own experiences of trying to get mediation expected? Well, one, I think, and Meg has already touched on this very well, is that treaties would need to be designed to contemplate a mediation step requirement. And here I sort of part ways with Meg, because I respect the view that you don't want to coerce anybody to go through mediation, but unfortunately, what I'll tell you is that the world of commercial arbitration and also the public experience in different countries with the courts is to get mediation started. Very often you need the coercive option. You actually need to bring one or both parties into the door. Once they experience mediation, most people become believers, if not evangelists, for the process. But a step requirement, and in fact a step requirement is one of the things that we are now increasingly including in our contracts, an obligation for parties to at least attempt resolution through mediation 45, 60, or 90 days before being allowed to initiate arbitration. The second point, which I think is related to this, is that there ought to be some sort of a doctrine as to good faith participation being required. And I make this point because you would not want a mediation requirement to simply become a box that parties feel that they have to check in order to be authorized to start the arbitration process. But you would almost need an international body of jurisprudence that would lead to even potential sanctions, as you see in some countries, for example, the UK, where if a party fails to at least engage in attempt settlement or mediation, they can be imposed with, for example, sanctions. The third point, and I was pleased to hear from Meg about ICSID's experiences, I think 6 cases is nothing to be ashamed of. I think 6 cases, if you look at a lot of the arbitration institutions, that's where a lot of people are starting out. It's a number that can grow and become bigger over time. But you do need mediation services being provided by someone. And I think ICSID is very well placed to promote and provide mediation services, as are many of the other dispute resolution institutions. There's actually a plethora out there of international mediation providers and arbitration providers who provide mediation services who could do this. The fourth thing, perhaps the most important thing that I think that we would need to see from our point of view would be an infrastructure that would need to evolve on the state side that would provide for and empower people to negotiate on behalf of the state interests, which is often the problem that we find when dealing both with governments but also with state-owned entities, that once you fall into a dispute, the easiest option is just to go to arbitration. And I'm often reminded of a conversation I had very early on when I started with GE Oil and Gas in a negotiation with the general manager of a refinery in Asia, who said, "We think you're probably right on this, but there's a dispute, and so on balance, it's here for us to let this matter go to arbitration." He says, "I'm afraid of being accused of corruption if I settle with you." So I think we really want to see some sort of an infrastructure on the state side. And then finally, the one thing I think is given the public interest here that we would need to see, and I hope that my good friend Wolf von Kumberg will be able to speak to this as well later, and that is a mechanism that would provide for transparency and competency of mediators. And again, Meg mentioned the difficult question, who are the mediators going to be? It's a question that we, on the company side, continually ask ourselves, and that's why Wolf is the former chairman of an organization called IMI. The AAA is also very much behind this initiative. I was the chairman last year. Patrick Dean of Nestle in Switzerland is the chair this year. And IMI exists to promote transparency and competency in mediation to make the whole process much more transparent for everybody. So just very quickly to conclude, to go back to the experience we had with the country where we did actually have a lawsuit with the state and kind of wish we had not, what would a mediation requirement step have accomplished for us? What it would have accomplished for me is that we would have been able to had our proposals, and by the way, we proposed mediation and it wasn't accepted. I think it would have generated a very positive result for GE that we would have been proud of to talk about today in public and could have used it as an example, rather than just simply saying, hey, the lawyers won an arbitration award. And I think it would have been a wonderful result, could have led to a wonderful result for the country in question. I think a lot of cases are ultimately going to wind up in arbitration, but even when you fail in mediation, when you get to arbitration, there are a number of advantages that you always are glad that you went down the process anyway. Not just the relationship saving, but educating yourselves on the overall case. And again, going back to having your early reasoned evaluation to make sure that the outcome you get at the end ought to be in line with your expectations as they were set at the beginning. That's all I've got to say.
Terrific. I hope we'll be hearing more from you, Michael. But for now, I'll thank you very much for those. Is there a question for Michael? Yes, please. Your name and will you make sure that Michael can hear you?
Jason Yacht, University of Wisconsin Law School. I guess I'm wondering what views, if any, Michael has on the role that arbitrators should or should not play in promoting settlement or mediation once a notice has been filed and a tribunal has been constituted. At that point, should arbitrators play any role whatsoever in encouraging the parties to think about settlement or not?
Are you able to hear that, Michael?
Yeah, no, I think arbitrators can play a tremendous role. You've got this range of competencies in arbitrators in helping parties actually reach a resolution. Bill Slate's organization, AAA, actually I've heard has a motto that they said they don't sell arbitration or mediation services, they sell solutions, which is actually, it's a rather interesting way to express what parties ultimately want. We want solutions from our cases. There's the very passive approach that many arbitrators take, which is, I'm just here to ultimately decide how things are going to turn out. File your pleadings, let's have a hearing, and I'll let you know how things stand in 3 years. The best way arbitrators can promote settlement is by giving the parties an early indication as to what the key issues are, how they may or may not likely come out, and put the parties in a better position to understand their ultimate rights so that they can facilitate on their own settlement. There's the upstream, from the passive to, I think, the very active role of arbitrators playing a role like judges do in a case, and I think business parties in particular, expect that. To the other extreme that you get in Germany, which I think is a great example, where in almost every case the judge or the arbitrators are almost going to twist your arm to try to reach a settlement. It can almost go a little bit over in the case of Germany, but I think there is a midpoint where just by being willing to have a little bit more courage during the management of the case, arbitrators can do a lot.
This is too rich an opportunity for me not to weigh in with a personal view, if I may. Thank you, Michael, for serving it up. In some respects, as I listened this morning to the arguments that were advanced as to why mediation may not work in the investment context, it was in some respects like Yogi Berra saying this is deja vu all over again. Because many of these same arguments, except for the very significant one of a government party, and I set that up as being a significant difference, although we did hear an answer from Aguie in that regard. Except for that difference, many of the same arguments that were advanced were said about why mediation would not work in international commercial arbitration matters. And they included the fact that you do not have the backing of the New York Convention, that in these complex international commercial arbitrations, these are multi-party cases, and it will be much more difficult for a mediator to sort out these many differences. And interestingly, we find with each passing year, the number of international commercial arbitration, some mega cases, are converted to mediations along the way. The percentage of cases is holding pretty steady, but because the caseload is going up, there are more cases every year. So 5 years ago, we had 30 cases that converted to mediations. Last year, we had 71 quite substantial international arbitration cases that came in as arbitrations and became mediations. And I don't want to suggest this as being the answer, if you will. It's too simplistic. But an element that I haven't heard discreetly addressed is the fact that someone, at least at the institutional level, has to be in charge of this. I don't think that it has to be mandatory. That's another question. But someone has to take responsibility for offering the mediation option and for educating the parties as to how this might take place, and for providing a legitimate list of competent subject matter expertise mediators who can function in the international context. Michael referenced IMI, the International Mediation Institute, which is a certifying body that now has an accessible website with over 1,000 qualified international mediators that in some respects goes to the question, where do I find a competent international mediator? So this will not happen on its own. It's not spontaneous generation or self-actuating. Someone has to step up and describe to the parties, I must be saying things that are crossing some issues because signs are going up. This is terrific. This is what you asked for, Cindy.
I know.
So, yes, there are what might be described as some practical obstacles here, but education and offering, and by the way, as the number of commercial arbitration mediations go up. What do we find is happening increasingly on the commercial side? And that is more public policy issues, more movements for third-party intervention are making their way subtly into the commercial process. So I don't mean to suggest there's a blending here, but some of the same issues which we see on the public law side are making their way into the commercial side. And international commercial mediation grows every year. There's another parenthetical I won't begin to go into. So does the number of large cases, billion-dollar cases, where parties initiate their case online. It happens. Yes, please. Gentleman here.
Thank you.
Please.
Yeah, one of the things that usually we may take into consideration, or probably one of the most important matters in terms of policy making process, is that precisely most of the developing countries that have right now bilateral investment treaties or even free trade agreements actually works with the model that comes from countries that export capital. So based on that, there is a huge disincentive to promote international arbitration or mediation, because the countries that actually negotiated those agreements are working with a model that do not fix the needs of the country's receiver that are receiving the investment capital. So based on that consideration, one of the things that we should think a little bit more is if the moment has come to evaluate the model of negotiation based on the needs of the country.
Yes.
Being from a developing country, usually I tend to think that we need to start working languages by which the other country understand that we need to go through a mediation process.
Yes. Thank you, sir. Please. Yes.
Yes, I just wanted to raise a variable that I think will be very useful to include in the equation. The time when the dispute comes, the differentiation between conflict management and settling of a dispute. And I say this because I fully agree with what has been said, that part of that, when you deal with states, you're dealing with a party that has very little space of maneuver, depending on the time that the dispute arises. What I mean is that most of these cases that go all the way to arbitration, by the time that you have a dispute already before exit, the political space to settle is very limited. But I'm sure that if there have been mechanisms that have been followed well before, in particular, if you just solve the dispute before it entails the whole state to use taxpayers' money to compensate, then I'm sure that the government officials will have much more leeway to negotiate. It will be much easier to have a good faith negotiation because no one wants to spend what, $2, $3, $4 million in a case, except probably the lawyers. But even if we give the lawyers incentives to help to mediate, well, then we'll have a new kind of way to serve this leadership. But the point that I want to make is that I think we have to begin to borrow for the experts here on dispute systems, import some general concepts into the investment part. Talking about, I really found Kathy Constantino, I didn't see her now, but about the construction on the difference between conflict management and dispute resolution.
I think that's a very profound.
The disputes are unsolved conflicts. If we have to solve that, then it will be much easier to deal with. And the key point, I think, is avoid using taxpayers' money to compensate. If we can catch the dispute well before that, it will be much easier to follow all the recommendations that I have heard today.
Very good. Thank you. I violated my own rules by taking the floor, and so I admitted more questions, but we're still at the one question level. You're going to have another opportunity when we open up the floor. But Michael, thank you so much for instigating this very interesting discussion. It's now time where, in the absence of Mr. Paredes from Peru, who is going to make some comments on Peruvian law, to have the benefit of Ana Juvenred's comments on that subject. And you have the floor.
Thank you very much. I'm going to speak from here because I really want to make it very, very short. Just making use of the fact that we did assist Peru in the design of the law that they have set up that is called the Law on State Response to investor-state disputes. So it says really what it is meant to address. And I'd like to pick up on 2 points. One that was mentioned earlier that has to do with the empowerment and with the defining who is in charge. And that's one of the items of this law. They set up a commission that is constituted of the Ministry of Economy, Ministry of Foreign Affairs, Ministry of Justice, and Pro-Inversión. Pro-Inversión in the sense that the whole purpose is that investors this is taking place in the context of investment promotion, and we want investors to stay, and we want to make sure that the investment promotion agency is also as closely involved. They also, each time a dispute arises, will include into the commission on an ad hoc basis the agency that is involved in the dispute. The second interesting feature of this law is the circulation of information. What they found out was precisely what has been mentioned earlier, that you have the central level of government that will make commitments under international investment treaties, and you have sub-layers of government beginning with the provinces, but that can go down to the municipalities and to various agencies that are dealing on a daily basis with investors and have no clue about the commitments that have been made by the central government. So one of the first aims of this law is to institute a two-way lane of circulation of information from the central government down to all the layers of the state that will involve the state, as we were mentioning this morning, as Mark Feldman and Mark Lockhart mentioned this morning. And the second is the other way, which is going from these various municipalities, provinces, up to the central level of government in what is called an alert system, where these agencies and the sub-layers of government can go back to this commission and say, we have a problem with an investor. Instead of letting things fester and not being able to deal with it, they have a direct avenue to this commission that has been set up. They have all sorts of other features that are very important in the conduct of the defense. Then, for example, the mandatory provision of information and documents from these various agencies to the commission that is in charge of the defense. But I think we're mentioning it in our publication that we prepared for this conference. But also you will find it online. It's it's on the Peruvian Ministry of Economy website. It's available there. You can find it and look at it. I think if I may just venture two sort of problems that may be infancy problems, but that have arisen with the implementation of this law, is the fact of having a four-headed commission. Doesn't make it easy to handle, because it's not one single agency that gets the help of the others, but it's really a four-heads commission plus a breathing agency, if I may say so, and that is sometimes quite heavy to implement and for a decision-making process, and particularly in the case of what they have identified in the law that they call trato directo, which is the mediation, the amicable settlement part, where the fact of being four agencies plus one to decide makes this particular step, which is, although provided by the law, makes it difficult for them to implement de facto. That's what I would say.
Preventive strategy in place, nonetheless.
Yes, exactly.
Would anyone have a question of Anna, respecting this Peruvian law? Yes, please.
Oh, Andrea Bjorklund from the University of California in Davis. Anna, I think this is just a terrific initiative. You know, I read the report, and the Peruvian system seems very well thought out and really excellent. And I wondered if other states are thinking of doing the same thing. Is there a room for, and you had
Are there other states that we might name? Yes.
Mine.
Mine, okay.
George, comment on this?
Just a comment on I'm currently not on an official capacity because I'm now working for our own reporter, but in my previous life I was director of investment, foreign investment in Colombia, and there are two elements that the directorship of foreign investment of the Ministry of Trade works on and already has. One is called SINOI, by its Spanish name, Sistema de Información de Obstáculos de Inversión. It's the system of information for investment obstacles. And basically what it does, it has, the investor informs the state and the investment agency and also the Ministry of Trade on those obstacles against investment, and the officials follow through, and the investment agency pretty much works in the same manner, in a similar manner as Aguie explained. The investment agency works in the Dominican Republic, so the investment officials know what the investment is about, etc. And if there's an obstacle, they follow through. To the extent possible, they try to solve the issue if it's not a treaty violation issue. If it's a permit, something that can be fastly fixated, it is arranged. So that's one element. The other element is now there is, or there was, or there is an initiative to create a lead agency, which would be one and not three. That's one of the issues that often occur. Who will lead the investment dispute resolution effort, or even worse, who will represent the state before an ICSID tribunal or an antitrust tribunal, etc. So that is another effort that is being done, and also making references to various of the responsibilities that a lead agency would have, either to try to solve the dispute or to work in cooperation with defense lawyers throughout a dispute. So, but I'll be addressing this later on.
Good, thank you, Jose, for sharing this. Again, we'll have a fulsome Q&A if you'll, I'm sure that's a great question if you'll hold Todd. Thank you. Well, we now have the great pleasure to hear from Andrea, who will examine existing strategies broadly, including dispute system design. The floor is yours.
Mark will be back, I promise.
Bye-bye. Yes.
Or Mike. Sorry, thanks. Hi, I'm Andrea Schneider from Marquette Law School, and it is a pleasure to be here. I've been teaching in international law and dispute resolution for longer than I care to admit at this point. And it is a rare conference where I get to bring both of those avenues together. So I appreciate Susan for doing this, and I like the description at lunch today of a formidable team, because that is clearly what we have witnessed today. What I'm going to do is start off with a little bit of background in terms of what we've seen as the evolution of the international system, then map on a little bit of the dispute resolution system in the United States, at least as it has evolved, and then move us forward to the dispute system design and really ask the questions that we've been dealing with more specifically today of where are we going from here. So now, of course, we have to have the challenge of which button and which slide. I hope we all have one more fun. Right? All right. Well, oh, there we go. Well, we're going to do that. There we go. All right. So this is an early chart looking at the 4 common systems that have evolved in international disputes, kind of regardless of the area of law. And so the negotiation system, also known as gunboat diplomacy, a fun reference to how we used to resolve things. Investment arbitration, our current system that we're talking about, international adjudication in which there is a court, as well as a supranational court modeled most closely by the European Court of Justice, and some of the common features that we've used in international law to distinguish
among the different types of dispute systems that were available along the international spectrum. So direct effect, in other words, whether you had the ability for that decision to immediately take hold, whether private actors had any standing, in other words, whether you only had countries who could participate, or whether individuals or companies could have some play in front of this particular mechanism. Supremacy, as in did this ruling coming down from either a court or a tribunal have any bearing on domestic law, transparency, which we've talked about today, and generally talking about enforcement. And this was very much of the question from the 80s into the 90s, into the early 2000s, really, as you would look at international systems as they were evolving. If you had been studying anything from trade to human rights to the evolution of the International Court of Justice, and its particular rulings, you would locate yourself along here. Another way of looking at this early on was something that I called a continuum of constitutionalization, but in other words, how embedded into domestic systems were these particular courts that had evolved in international law, with the negotiation regime obviously being the weakest. It would have no particular play kind of issue to issue, dividing out depending on the issue as to whether you used investment, arbitration, or the international adjudication, and again, the supranational court being the strongest. And one of the interesting things that I looked at in international law was that if you studied the history kind of in the 80s, 90s, early 2000s, that there was this increasing judicialization, what's called legalization, constitutionalization. It depended on which scholar was using which term, but that there was this increasing judicialization of international law. The idea that negotiated remedies and diplomacy was not going to work for a whole host of disputes, particularly in trade, but you could see this in border disputes, human rights, whatever it was, and that countries were more and more willing to rely on tribunals or courts of some way to resolve their disputes. And it was this very interesting track going on. If you were tracking the international system, there's been plenty of international law symposia on really the development of the international system. And I'll come back to that in a moment, but I wanted to start there. The second thing was this development, kind of a parallel track, the development of dispute resolution processes in the United States. Most U.S. commentators date this somewhere around 1976, the Pound Conference, and the creation of dispute resolution, which becomes more and more court-connected to the point where if you picked up a dispute resolution book written in the late 80s or the early 90s in a law school classroom in the United States, it would explain to you why dispute resolution is needed and why we need mediation. And these days, you don't even bother with that argument. It is there. Any litigator who is now graduating law school and about to go into litigation knows full well that they will be mediating their case long before they will see a judge. That battle in some ways is over. But the idea here to just present the spectrum really of processes that have evolved and continue to be used in a variety of different levels in the United States, with direct negotiation, obviously still the classic settle on the steps of the courthouse, has always been and will always continue to be part and parcel of any process. Obviously, at the other end, you've got the trial. To place what's going on in the investment system, you would look at arbitration. And so it's not quite trial, but you have the arbitration there. Bracketed and final offer arbitration are both systems which limit the awards for arbitration, again, not used in investment arbitration, but often used in commercial arbitration, where you'd like to limit some of the discretion of the arbitrator. And on the other side of the need-arb divide would be the non-binding ADR processes. And to locate our discussion, I think that's where we are spending much of our time kind of thinking about what else could we bring to bear on investment arbitration. What other processes could we add to the mix that are in between your direct negotiation and your arbitration? And how do you institutionalize those particular process choices in a way that takes advantage of much of what we've heard today already from our participants and from those representing countries in particular. I'll note that arbitration already in the commercial sector, we've heard some complaints about it used in the investment sector, but in the commercial sector, no less an authority than Tom Stepanovich, who is considered one of the gods of arbitration, former chair of CPR, now Professor Pepperdine, refers to arbitration as the new litigation. That arbitration, as it's used commercially, internationally, and domestically, is so expensive, so time-consuming, has evolved with so many rules that it, too, no longer offers the benefits that those parties who initially were all into arbitration are finding. And so if arbitration is the new litigation, what are we doing? I don't think that that is where investment arbitration is yet, but it is one of those things, and I was kind of going, but recognizing that already in the commercial sector, with many of the parties, like Michael represents GE, other parties are already seeing that arbitration has gone even further along on that spectrum. A couple other definitional things, just so that the dispute resolution people and our international people are talking the same language. So in reading the reports, UNCTAD and others have referred to fact-finding for dispute resolution. We would call that early neutral evaluation, but that's one and the same. In the chart behind me, it's basically a neutral person with expertise who would come in early, look at the case, and come back with some facts, some evaluation as to what's going on. Two other terms just to define up here are facilitative versus evaluative mediation. And as we start to, this afternoon and moving forward, talking more particularly about what we need for mediators, it is a distinction to be thinking about. Do you want the mediator to be coming in and telling you, this is what I think, this is what I know, these are the options that I've seen, or do we want a mediator who's more turning to the parties and saying, what makes sense for you? It's a little more sophisticated a conversation. I know we will get there. It is a conversation that is ongoing and continuing in the domestic arena, shall I say, as we look at what's going on in the United States. So the interesting thing for me has been in the past, shall we say, 15 years, as watching the international system become far more judicialized, while at home I'm teaching a system that is running away from trials and is now called the vanishing trial. And how in the world are we actually operating in the same way with players going in what seems opposite directions on that spectrum? And what I've looked at is really this concept of procedural justice and voice. So that we know from looking at the international system, we moved toward judicialization, towards a decision-making process which was perceived as fairer. It balanced power better between those countries that were less developed and more developed. It provided voice, it provided representation, and it was a way of ensuring that fairness and procedural justice was provided in the international system when it was perceived earlier on that that was not the case. Domestically, it's exactly the opposite. So that courts, the time to get a decision, the amount of money that was necessary, disadvantaged plaintiffs, so on and so forth, led to a movement towards dispute resolution whereby saving money, providing parties with more power over their results, and giving them a seat at the table in consensual dispute resolution was providing that procedural justice. And my point here is, as we're really trying to merge what have become consensual dispute resolution processes concerned with voice and procedural justice with international institutions that were also created to provide that procedural justice, we need to make sure we're not losing that. We need to make sure that that is the thing that does not fall out. And so as we create our process to be sure that that voice, that representation, that fairness, that accountability is maintained, whether those processes are consensual or are adjudicative as we're moving forward. So that is where we get to with dispute system design. And just to give a highlight of where dispute system design has been used, it is a quite extensive and quite flexible process. So I'm not going to show up today with the answer, as it were, to this is, I'm sorry, Anna, this is the fix of what one should do. But what I will suggest is that we have a framework. We have a very good framework that has been proven to be very flexible as dispute resolutions evolved and taken place, where you've been able to use this in a variety of transactions, everything from mass torts and class actions all the way to organizational situations. So I'm going to move exceedingly rapidly. You have process design principles, and I know Kathy, when she returns back this afternoon, will spend a little more time on this. First, that we need to think about participation. Who's there? This is obviously a start to have all of us around the table and to be thinking about funding, support, technical, legal training, and things like that. Second question is suitability. When is mediation the right process and when is it not? There are those cases that are right for arbitration the same way we would say that these are the decisions that should stay in court. And as we look at the cases that have settled either without help or with help, recognizing we're not trying to settle every single case or to pull arbitration out of it. Recognizing and being aware of the political and domestic constraints. The cover that a court or an arbitration provides to say it wasn't me, it was them. And on the other hand, hearing from our players that sometimes coming home with an arbitration loss or the costs that it takes to get through it are also important. And I want to note from the blog, several of you wrote about cultural understandings of mediation, and we want to recognize that there are plenty of cultures around the world that use mediation far more extensively than Western cultures, and this is already embedded. This is something to be taking advantage of. Thinking about process accountability, so what is the process that we use, thinking about the education, representation, legal services that do need to be provided as we go through the skilled mediators we've already discussed, and obviously transparency and follow-up. That is different from the results accountability, so how do we track what happens not only in the course of the process, but what happens after the end of the process? What decisions do we make about transparency? Tracking, which hopefully has the advantage of repeat players in terms of countries and municipalities, sectors where those problems continually arise. Fluidity is a key thing to think about in dispute system, recognizing we've heard about the dynamism of investment law, and we want a system that is not static. We don't want to create something that is old and outdated the moment it starts. Thinking about sustainability, do we embed this into the treaty? Is that the wiser thing? Do we embed it into institutions? What kind of training and assumptions are needed? And as many of you have already mentioned, talking about the delegation of settlement responsibilities and the real rejiggering of who's responsible for what that needs to occur for something like this to be more sustainable. The last point is permeability. In other words, the ability to go throughout the system. And here's where so many of you on the blog and today have already given examples, whether it's in the Ombuds office, in the aftercare that we just heard of, which I think is fabulous, building in informational exchange both within the country as well as with its investment partners, administrative review, and things like that. So where do we go from here? In response to this morning's comment, we absolutely need and want the shadow of investment arbitration. You can't do this without a working legal system behind it, whatever that shadow is, and you need it. We need to better structure the time that occurs between whenever that original conflict starts and the final arbitration result, and not separate only the 3 months or the 6 months that you might have before the filing, but really think about a process that takes advantage throughout. Offer process choices between the negotiation and binding arbitration, and dispute system design is up to the challenge.
Is there a question for Andrew? Yes, please.
Andrew, you referred to that, the tension between the international development where there had been greater judicialisation of dispute resolution and domestic where there had been a shift in a sense away from courts to ADR. And I'm just wondering whether there isn't quite an interesting kind of synthesis there in the sense that it's perhaps where you were getting to right towards the end of the presentation, that a way of institutionalising mediation is through courts and tribunal systems. And no one yet has made any reference to the possibility of a permanent court for investment disputes or to review of exit arbitral awards, because that isn't really part of the agenda. But
if one did go down that track, it would provide that institutional context in which you could have either pre-hearing mediation or pre-appellate mediation. Have you considered that?
I'm not suggesting a court of investment of investment disputes. I think what we've seen is that when there is a court per se, it's easier to build in some ways that institutionalization. It's also easier to have that clear precedent, so that we're talking about bargaining in the shadow of what is clear precedent. And I've written elsewhere about human rights, where now that we have all of the criminal law coming out of Yugoslavia or Rwanda, elsewhere, you're far more likely to see those plea bargains because you know what you're going to get anyway. I think the argument here would be that there are sufficient cases, or at some time will be sufficient cases, that if that provides sufficient precedent and that you have sufficient institutional support, which is the other thing that a court system provides. I don't know that that's necessary. I mean, I think the institutionalization is really that technical support as well as the decisions, so you know what you're going to get, that predictability, as it were.
All right. Thank you. And thank you again, Andrea. And now, Josh, our commentator, perhaps you'll tell us what you make of what you've heard, or
Sure.
perhaps maybe even some aspects on the subject that you haven't heard.
Sure. Well, thanks, Bill. I think the first thing I want to observe is that the comment that arbitration is the new litigation is so apt that I think it's almost more appropriate to say that litigation is the new arbitration in terms of being time-consuming and expensive. I've litigated or arbitrated these cases before, but I've probably spent more time negotiating them and sort of structuring a negotiation agenda in the governmental context. And so what I want to try to do is graft my own experiences and perspectives onto what's been said here today. It's just a fantastic panel, and the whole event has been fantastic. I think it's important to start really from some first principles, which is, the key first principle is that international organizations do not negotiate treaties. Sovereign states do. Sovereign states pursue national interests, and almost by definition, the set of interests and set of objectives that a given nation state is going to pursue will be different. It's different political systems, different cultures, different governance structures, different civil society dynamics, and so the individual objectives of any given country or state are never going to be quite the same, and they're never going to be doing it in exactly the same political context as they themselves might be doing 5 years before, 5 years hence. So what that has sort of shown me over the years is that it's important not to get too wrapped around the axle about formal systems of dispute settlement and worrying so much about picking the right thing or the right system or systems off, out of the taxonomy of things that might be available, with the hope that if we just work hard enough and think, we can craft the right system that we can apply universally and that we'll be able most efficiently and effectively to resolve all manner of disputes and conflicts that come around. They won't. That the value of the taxonomy, and on that note, I thought your PowerPoint was fantastic, and I hope we can all get a copy, is to have a set of tools and to allow nation states negotiating these treaties to decide which tools are most appropriate for them. I think the more fundamental objective for any government, and for all of us who sort of worry about what governments do in the investment context, is to try to create the conditions early enough in the process so that conflicts can be resolved well. I don't think it's any fancier than that. The actual system for resolving it, again, is just a tool. Anna's comments about Peru and just the Peruvian experience are really illustrative in this regard. I think that while I don't know it chapter and verse, it is the Peruvian example that a lot of us refer to repeatedly in identifying the way to create the right kinds of conditions. And so what I want to do, just very briefly, is identify what in my experience seem to be the most important stages of condition creating that can allow governments and countries to be sort of structurally prepared to resolve, well, ideally prevent, but if necessary, resolve conflicts in a productive, mutually beneficial way. The first stage is really the preparation stage, and Meg, in the beginning of her remarks, referred to the importance of letting everyone in the government know what you're about to sign on to. What that requires, and again, while it's difficult to generalize across states, I think there is kind of a general principle that's helpful, is that countries really develop strong interagency relationships, strong intragovernmental understandings of what individual ministry objectives are, what the legal regimes are that they're pursuing, and what the legal obligations are that they may be taking on in treaties, so that at a very early stage, countries have effectively a strike team of experts in every area, not just in the economic agencies, but from environmental ministries and transportation ministries and all of these sort of single issue agencies that often end up being very fundamental and very surprised when their regulations and their laws are challenged in billion-dollar arbitrations. Creating a team, creating an interagency team that you can kind of go with over the years. That's number one. Second stage is the prevention stage. Basically what this means is you've prepared your team, you've negotiated your treaty, you've got people more or less on board with respect to what you want to do. Don't forget about what you've done. You don't finish a treaty and then just put it on a shelf and hope everything turns out okay. It's absolutely critical to do the kinds of aftercare that Aguie talked about from day one after a treaty is entered into force. So that means continuing to mobilize the interagency team, engaging with big companies, engaging with chambers of commerce, making sure that there is a relationship being cultivated between and among all players in the investment relationship. Hopefully you never need to rely on it when a dispute arises, because you will have no disputes, but realistically you will, which is where the third stage comes into play. The third stage is kind of getting into the dispute settlement set of issues that we've been talking about, which is essentially the management stage. If you have prepared and prevented reasonably well, then you're going to be in a lot better position to manage conflicts that arise. You have a rapid response team that can sort of mobilize quickly. You've cultivated relationships over the years with business interests in the country. And so ideally, you can get to a point pretty quickly when conflicts arise where you can sit down and talk about things, and you can at least start from a background of some degree of openness and exchange and an ability to talk to each other. That's where the dispute settlement mechanisms come into play, whether or not you've chosen facilitative mediation or more significant arbitration mechanism. You have got sort of the predicate for a good probability of success when it comes to resolving a dispute without going to full-blown arbitration. This is where a point that Michael made comes into play pretty acutely, which is that for this management process to work, for the management stage to be successful, people in the government have to have the power to negotiate. They have to have the ability to make deals, and they have to have more than just their careers and their bureaucratic interests to worry about. It's a very difficult set of conditions to create, but certainly to the extent it exists, it will make the likelihood of full-blown disputes go down. That really is just a sort of thumbnail sketch of some of the sort of stages of dispute prevention and management that have kind of coalesced for me over the years. Fantastic conference. Thanks again to Susan and Anna just for being here. I will wrap it up right now.
Terrific. Thank you. Thank you so much, Josh. Is there a question for Josh? Yes, Peter.
It's a comment more than a question, and I'm Peter Phillips. I would like, I guess, to take a moment to sort of put a stake in the ground here, because I think we're in the right place now, and we're starting to use the right terms and the right imagination and the right discourse. I guess I would ask if we're also prepared to perhaps, if not jettison, then at least think skeptically about the idea that we're talking in the shadow of arbitration. I hope we're talking in the shadow of how do we solve problems that arise between parties to a contract who, when the contract was entered into, intended that they make money from it. And conditions have changed, and now they have to figure out a way that they can continue to make money on different terms, as Mike McIlwrath has pointed out. And I'm reminded, since it is right toward the end of March, that opening day is right around the corner, and all of our thoughts are on Major League Baseball, which has a arbitration provision that I think is intentionally dysfunctional and onerous. It provides that in the event of a dispute that can't be negotiated, the parties will present their last and final offers to an arbitrator. That means that each party's offer is not optimal. Neither party wants to present to the arbitrator the actual value of the player. And the outcome of that arbitration is going to be economically inefficient. And I think that the effect of that arbitration clause is to ensure that it is never used. Always the parties use the fact that if they can't resolve this, they're going to have to end up with this stupid arbitration clause to actually negotiate a resolution of it. Now, it's the resolution process which recognizes that all the parties to that contract want it to work. That actually drives economically those dispute resolution mechanisms. And I'm suggesting that perhaps we might, if we really want to think out of the box a little bit, regard investor-state arbitrations as a too expensive, too long, too commercially irrational, dysfunctional process from which we need to find a more problem-solving approach. I don't know whether one exists in the shadow of the other, but surely the kind of conversation we're having now seems to focus less on dispute resolution than on solving the problems that happen in long-term commercial contracts in a way that is principled, consistent, and one hopes broadly applicable. But the test is going to be whether the parties themselves receive value from it.
Thank you. I think we're at the open Q&A moment, and so please identify yourself and let us hear from you.
Nancy Welsh, and I suspect that we might agree, Peter. We looked at a particular procedure, but I want to emphasize again the point that Andrea was making about the importance not just of this being economically viable in an economic sense, but also that these are procedures that are viewed as just. That there really is an opportunity for the parties who are involved in disputes to have a voice, to know that what they have said has been considered, to be treated in a dignified way, to be treated in a way that they believe is even-handed, open-minded. And I think that we need to be sure that the arbitration system that is in place continues to meet those criteria. So that anything that is happening within the procedural shadow of arbitration also mimics that procedural justice that's provided. And along that line, I'm curious whether we might also want to look at whether or not procedural justice is being provided in the development of treaties. For example, not just whether there's interagency consultation at a national level, but especially if there's going to be subnational implementation that's required, whether there's consultation that's occurring as the treaties are put together.
I think it's not disputed that one of the great deficiencies in this entire field is the absence of data. You just touched upon that here and there. And as a result, the field opens itself up broadly for anecdote and unsubstantiated suppositions across the, on the plus side and on the negative side. So if there's something that we wanted to collectively do here that would inform us and others who wish to avail these processes, we'd really get serious about a global knowledge bank and the collection of data. It's a huge, huge deficiency. Yes, Susan?
I just wanted to see if we could benefit from the fact that Josh is here. I had the good fortune of being at the ASOL conference last week and hearing his boss speak about the U.S. Model bilateral investment treaty revisions, which are currently in process. And when I asked him point blank when we could look for it, he said, we're working on it. Right? But that having been said, I understand that you were quite actively involved in the subcommittee that was a very broad set of stakeholders that were looking at the revision of the model treaty. And I was wondering, for the benefit of our guests, such as Aguie, who is interested in how do you do it, and for Roberto, who was also talking about this, what kind of conversations did you have, if you were in a position to say so, during that subcommittee process related to ADR and essentially dispute prevention and effective management?
Sure, no, I'd be happy to. I should clarify, Tim's not my boss. He's the general counsel, and I'm no longer practicing law, although I'm sure I engage in the unauthorized practice of law quite a lot, as Mark will remind me. We started the model bit review a little over a year ago. U.S. Trade Representative in the State Department co-lead the U.S. bid program, and so I and my counterpart at the State Department, who works with Fred Stillwell here, a gentleman named Wes Schultz, have been sort of co-chairing that process. One of the early decisions we made was to use a State Department mechanism, an advisory committee on international economic policy, which is really a pretty impressive entity because it does bring together, on a standing basis, stakeholders from across the range of interests. It's not just business people, but it's also people in labor and academia, environmental groups, and so forth. And so what we did was to create a sort of a subcommittee of that committee to focus on the model bit review. And we actually had co-chairs. From one person was from the business side of the House, Al Larson, who's a former eminent diplomat of the State Department, is now in private practice, and Thea Lee from AFL-CIO, precisely because we knew to get it right, we had to be integrating the views not just of companies and business associations, but of labor, environmental groups, and other public interest organizations. After we instituted that group, we actually stepped back for several months, so mostly over the course of last summer. Ted was on the investment subcommittee. I'm not sure where he's gone off to. Maybe he anticipated this question and took off. But we stepped away because we didn't want the government, we didn't want there to be this perception that the government was meddling in the deliberations of a multi-stakeholder group. And we just kind of set them off, and they, I think, just kind of beat the socks out of each other over the course of the summer over a variety of issues related to the model bit, which is exactly what we wanted to do. That's the way you have to have this kind of a debate. And some of those issues had to do with dispute settlement and how to structure a dispute settlement system that is not just valuable and useful to investors, but also doesn't inappropriately infringe the regulatory discretion of of governance. And so that involved both simple procedural rules, but also things like transparency, public participation. We were starting from a base, as Mark talked a little bit about the 2004 model bit this morning, that is already pretty innovative on this stuff. And so I won't draw any conclusions myself. I will say that the output of that subcommittee is public. It's on the State Department website. They came up with about I think it was about a 35-page report that had a few areas of consensus, but was mostly a catalog of competing views on issues, and then maybe 35 pages of appendices setting out individual stakeholders' views. But it certainly is the case that these issues of dispute settlement design were prominent in the course of the model bit review. I can't comment on how prominent they will be in the outcome, which we're hoping to have very soon, but they're certainly very important.
Thank you. Well, we regrettably are virtually out of time, but I see there's a question here. Please.
Mark Jackson, I wonder whether we should clarify what the purpose of alternative dispute resolution is. In the last two panels, I'm hearing different things. Originally, I thought the idea was that alternative dispute resolution is to facilitate and expedite resolution, so not make it too expensive. But from what I hear from representatives of some of the countries is that they also intend to change the substantive law, the trend in which bits are being interpreted in arbitration disputes. And I wonder whether that actually fits into the model of dispute resolution, alternative dispute resolution, because the alternative dispute resolution, the poor mediator, has to function within the existing interpretation of what fair and equitable treatment is, or what investment is, and so forth. And if it wants to begin to change the substantive law, the party who's going to be a loser is not going to accept that. So I think we should sort of, we're just creating one more, perhaps, compulsory layer of dispute settlement that is only going to add cost to dispute resolution. So I think we should clarify as to if you're going into this procedure, what is it that we're trying to do?
And would the mandatory nature of it be the linchpin for that
I don't
conclusion?
think so. I think either way, even if it's an alternative, it's with the party's expectation going to dispute resolution alternative is that what is it we're trying to do? To expedite the procedure, but based on the existing sort of a case law, or they're trying to change the case law. I think that's the key.
Michael, comment?
Hey, Bill, I could do a quick response to that, because it's actually an argument that we hear occasionally in response to why would we want to mediate. Oops, the security just turned off the lights.
We see you, Michael. We see you.
Tell the cameras.
I think the security guard could be walking by in a minute. I want to say that it is not, in our experience, mediation does not add costs, because to the extent you have to prepare for mediation, and you should, and you do prepare for mediation, it's almost always the same work that you would do in preparing for an arbitration. So it's the same work, and then the mediation itself, at least in our cases, rarely goes beyond 2 days. Usually it's just 1 day. And what I'd say more generally in response to I understand the concerns, I'd say you got to look around the rest of the world and see what's happening with dispute resolution generally, which is that, look, courts in different countries are moving towards requiring mediation. It's not just the United States, but also the UK. In Norway it happened. Italy just passed a law requiring mediation. It's a trend international. Companies are putting it in contracts. I'm not one, by the way, to dump on arbitration. Great respect for Tom Stefanovich, but I think in many parts of the world we would not say that arbitration is the new litigation, that arbitration functions just fine out in many different jurisdictions, but just the same, mediation is making headway. It's not necessarily an alternative to arbitration or litigation, but a different tool that you have in your toolbox. Interestingly enough, I hear and I'm sympathetic to the arguments about rights-based determinations. I understood Nancy's comment very well. There needs to be procedural fairness. I think lurking underneath a lot of this is a concern about corruption that you get in different countries, and you want to have, obviously, transparency and lights shining on the process. But interesting enough, I'll tell you, I had a conversation a couple of weeks ago with Carolyn Reese, who was working with John Ruggie, who's the Special Ambassador to the United Nations for corporate responsibility, and was developing a program to help local indigenous populations work with multinationals as companies like mine and others move into parts of the emerging world so that corporations with big financial interests and small community groups can work out their interests and find a way to get together. She gave me a wonderful example that says you have a mine, you don't do mining, but she gave me an example of a mining company. Says when a mine comes into a region, there are all kinds of problems that need to be worked out, and when you set up a way of resolving disputes that sets up mediation as a mechanism, they actually take that mechanism and it stays, and they use it as the mine leaves, because you have different problems that come along with that. So I guess my overall question would be not so much how you do this, but almost when are you going to do it? When will investment dispute become more like what everybody else is doing in the world of dispute resolution, in acknowledging that this is one of the best tools available for finding resolutions that fit all parties' interests?
Thank you, Michael. When Susan starts walking this way, you're finished. Thank you. Thank you for the question.
Thank you, Michael. I think that we're starting to see with this panel in particular that we can think a little bit about managing investment disputes like forest fires. We can either think about what Smokey the Bear would say, namely preventing forest fires, or we can deal with them when they have them, irrespective of the substantive layers. But that's an important part of the conversation as well. So thank you very much to our moderators and our speakers and commentators. Really I would also like to thank Kroll and Mooring, who is the sponsor of our tea break in proper kind of almost British fashion. So I'd like to invite you all out to the atrium so that we can enjoy coffee, tea, and a variety of delicacies from the Southerners. Thank you so much.